Good afternoon, everyone. Can you hear me?
Yes, we can hear you, Hussein.
Okay, thank you very much. Good afternoon. Amarachi, Amina, Adam, Christiana, Exter, Nicholas, and our mentor, Miss Rita. Good afternoon, everyone. Good afternoon, Stephanie, Yusuf, Kalima, and Linda. Thank you all for joining the call so early. I hope we are all having a wonderful day. As we all know, today is the week 2 of Jiipcc Mentorship and Internship Program on intellectual property. And the topic for today is intellectual property registration, infringements, and enforcement. And I'll be the moderator for today. My name is Hussein Mahadi. Quickly, I'll be taking a few announcements before we jump to the main program of today. I'll be telling us about the program. For some of us, we've heard about it before. For some of us that are joining new, that are hearing for the first time. Jiipcc Mentorship and Internship Program is a quarterly program for students and young professionals across Africa. Mentees are afforded the opportunity to access valuable advice, training, network, mentorship, internship discussion forums, industry updates, and resource materials from experienced mentors. The program seeks to encourage continuous training, development, and evolution in Africa and around the world. You can watch some of our previous videos from our YouTube sites, our Facebook, our LinkedIn. You go there, just search YouTube, Jiipcc MIP, and you see most of our content. Some of the objectives of the program is to provide easy access to quality professional guidance, training, and resource materials for students and young professionals in Africa, to facilitate dialogue and network among experienced and less experienced practitioners and stakeholders, and to transform mentees into mentors and leaders for the next generation, and also to facilitate further mentorship, internship, and scholarship and job placements for its mentees. So that's a brief summary of what Jiipcc is all about. You can still take advantage of the 30-minute one-on-one mentorship session with your favorite Jiipcc mentor with the link bit.ly/jiipccpm. You can get live hacks, secrets, live lessons, directions from your favorite Jiipcc mentor. Kindly reach out to either of the Jiipcc management team to, if you are interested in this, to get the appropriate link to register. I will also be introducing our mentors by reading their profile before we take their presentation. So our first mentor for today is Miss Rita Anwiri Chinda. Okay. Rita Anwiri Chinda is a lecturer at the Rivers State University and intellectual property consultant for IGA Nigeria Limited, who is the heritage consultant for the Lagos State government, where she provides legal advice on how to commercialize and monetize the culture, tourism, and heritage of Lagos State by exploring the intangible assets of the state that the state has. She holds a master's degree in intellectual property and information technology from the University of Derby, United Kingdom. The podcast host of IP series, which features conversations on recent intellectual property cases and development globally, and has 97 episodes published with 19 blog posts edition on Substack. She is part of the team that drafted the Rivers State ICT policy, a 3-time judge for the Adavize Allow essay competition on privacy data protection in 2019, 2020, and 2021. A member of the technical working group drafting the geographical indication law for Nigeria in collaboration with African Intellectual Property Rights and Innovation in Africa, AFRI-PI, and Africa International Trade and Commerce Research, AITCR, sponsored by the EU as chief convener of the Intellectual Property Society of Nigeria, IPSN. Her team and she and her team had organized 2 virtual conferences which took place every last Friday in October and celebrated One World Intellectual Property Day. By creating awareness and educating students, colleagues, creative innovators, and sectors that interface with intellectual property, she has spoken at various events, both physically and virtually. In 2022, she won the award for Tech and Innovation in Law at the 4th anniversary of the Young Legal Professional, YLP, which was held on 30th July 2022 in Lagos with the team, the Grand Ball. This award recognizes the member of the group who has best demonstrated awesome skills and talents in tech and emerging areas of law. She is a member of the Chartered Institute of Arbitrators, Young Member Group, Global Steering Committee. She also won the 40 Under 40 Rising Star Award organized by ESQ Nigerian Legal Award in 2021. She is the chief convener of the Intellectual Property Society of Nigeria, currently PRO of the Chartered Institute of Arbitrators Port Harcourt chapter, Pro Team Secretary, Young Member Groups of Chartered Institute of Arbitrators Port Harcourt chapter, listed in the inaugural edition of ESQ Legal Practice magazine as one of the leading Nigerian women in business law. Okay, she also featured in the inaugural edition of the All Things IP Africa magazine 2021 Young Legal Professional Recipients Award of Excellence, 2020 WIPR Influential Women in IP Tribalizer. She is a legal advisor for the River State Musician Guild. She has also spoken at various intellectual property events. Okay, I've said this before. Okay, virtually, both physically and virtually, and Keta, President, Rotary Club for Port Harcourt, Greenbelt. Okay, she enjoyed watching South Korean movies, wow, and series, and listening to music, traveling, lounging when she can, and adores dog. Thank you very much for joining us today, Miss Rita. Your profile is very long. So I'll be reading the next mentor's profile, Mr. Christian Anyuku is a graduate of law from the University of Nigeria, where he obtained his LLB in 2014. He thereafter proceeded to the Nigerian Law School, Abuja, from where he graduated in 2015 and obtained the Council of Legal Education Qualification Certificate, BL. He was called to the Nigerian Bar in 2015. Christian obtained his master's in law degree with a concentration in LLM and IP and technology law cum laude from University of Illinois, Urbana-Champaign, USA. In 2021, Christian has acquired many certifications from several IP courses, including the Harvard Law School Copyright X program, WIPO Advanced International Certificate course on IP, Panorama, etc. Christian work experience spanned through his experience as a litigation attorney, IP associate at Aluko and Oyebode, Lagos office, research assistant to head of IP department, University of Nigeria, as well as research assistants to 4 judicial officers. Christian, in his current position as the IP associate at Aluko and Oyebode, managed the IP portfolio of several multinationals and renders bespoke IP management advisory to clients. He specializes in brand protection and anti-counterfeiting action. Christian has authored and published several articles in IP-related topics, both on international and local platforms. Christian is a member of several national and international groups and associations, including the Nigerian Bar Association, American Bar Association, Intellectual Property Law Association of Nigeria, International Trademark Association, NBASBL IP Committee, Anti-Counterfeiting Collaboration, among others. He was recently appointed a member of the Geographical Indications Committee. Thank you very much for joining us today, Mr. Christian Aniuku. Our third mentor for today is Ms. Amusa Shukrat Mudupeola, who is a proficient consultant, analyst, and educator in the field of intellectual property with public sector experience. She is a member of the World Intellectual Property Organization Committee and has a master's degree in intellectual property at African University, Zimbabwe, in conjunction with WIPO and the Japan government. She has partaken in professional training at the WIPO, as well as other IP-related bodies, and has facilitated numerous intellectual property-related programs, both online and offline. Ms. Shukurat is the pioneer of an educational platform, The Intangible Nuggets, which facilitates IP awareness and brings the knowledge of intellectual property closer to everyone. In celebration of the 2022 World IP Day, she partnered with other stakeholders to sponsor 5 IP enthusiasts and registered them for WIPO advanced courses. Ms. Amusa is an accredited agent at the Nigerian Intellectual Property Office, Nigerian Copyright Commission, Trademark, Patent, and Design Registry, and her expertise are but not limited to trademark, patents, industry design, copyrights, and trade secrets, respectively. And our last mentor and fourth mentor for today is Mr. Max Ikongbe. Mr. Max is the founder, principal of Ever Law Associates. He works extensively in the field of arbitration, ICT, technology law, and intellectual property. Mr. Max is a facilitator on the annual Information Technology and the Law course of Nigerian Institute of Advanced Legal Studies since 2016. He has trained in advanced intellectual property law courses at the WIPO Academy, and he is an accredited agent of the Nigerian Trademark and Patent Registry and has conducted IP registration business since 2010. Thank you very much for joining us also, Mr. Max Ikongbe. Those are our 3 mentors for today. I'll be calling on our first mentor. I can see the attendance from our mentee is very poor, please. My backup moderator can just help me send a message across on their group that it's time for our meeting. Thank you very much. So I'm calling on Ms. Rita to start her talk and also overview on the topic for today, IP registration, infringement, and enforcement.
Okay. Good evening. I thought the students actually going to present first, and then we'll make contributions. But basically, thank you to Jiipcc for inviting me here. I see that my mentor of life, Max, is here, and I also see Christian is here, and Shukrat as well. So you guys are in good hands for today's conversation. So the topic I don't have any presentation. Apologies for that, but I just want the conversation to just flow naturally. So I believe by now we already have foundation on what IP is and the types of IP mechanisms. And then we'll now delve into the monetization aspect, which is where conversations on IP registration, IP infringement, and enforcement will come into play. So first of all, as either a creative or an inventor or someone who is taking advantage of his or her human intellect, one of the things that you need to decide pre-market stage or post-market stage is identifying the relevant intellectual property that you have created that you feel has commercial value and decide to register it. Now, do you want to just focus on your jurisdiction where you are based? These are some of the questions you want to ask yourself and your team. Are you looking to expand to other jurisdictions? If yes, what is the strategy and plan to that? Do you intend to engage relevant stakeholders in that jurisdiction? What are your commercialization strategy in terms of licensing and getting a franchise and all of that? So once that is settled, you, if it's a copyright, you verify with your lawyer that your work in question is eligible under the Nigerian Copyright Act. Now have a new Copyright Act, which is the Copyright Act 2022. Amongst all of the IPs, copyright is the only IP that gives you some sort of leverage or an edge over the other IPs, where as long as it's in a fixed or tangible format and it's or it has original characters and has been expressed, you already enjoy protection. However, the new Copyright Act, section 4 and 80, either 84, 87, one of them, I can't remember now, but the provision now states that copyright owners may, so it's not mandatory that you should register, but in the event where there's a dispute as to ownership or authorship and all of those conversations, you can reach out to the Copyright Commission for a CTC that you can present as evidence or as your documentation in the course of the dispute. Whereas for trademark, what you focus on is section 9 and 10, which talks about being capable of distinguishing and also being distinctive in nature. Then you also have considerations as to things that cannot be registered, a descriptive mark. So a mark that when you hear it, you already know what the product or service might be about is descriptive. Is it generic? Meaning, are you using a common term that people is already being used in the public domain? And for patent and industrial design, it has to be new, novel. For patent, is not obviously a skilled person. Then for plant variety, you have that it has to be uniform, distinct, and I think new, because we now have the Plant Variety Protection Act in Nigeria. And what we do not currently have is the GI, which is the Geographical Indication Law, but that is currently under
I can't hear Miss Rita. Can you all hear her? Please let's indicate. Can we hear Miss Rita? I don't know. I can't hear her from my own.
She went off, but she seems online.
Okay. So I'll call on our next mentor to step in while we are waiting for Miss Rita. Mr. Christian. Mr. Mr. Christian, are you with us, please?
All right. So, good afternoon, everybody.
Good afternoon, sir.
Yeah. So I'm a little bit, I would say confused, but I think the procedure has changed. Back in the days, it used to be presentations first, then the mentors will give comments before taking questions. But now it seems we are to give some comments too. So I don't have a presentation, but I looked at the topic IP registration, infringement, and enforcement, and it's practically something we do every day, right? As an IP attorney, is something we do on a daily basis. So when you talk of IP registration, how many minutes do I have? Sorry, let me.
You have like 10 minutes, 10 to 15 minutes.
All right. So when you talk of IP registration, then I think first thing is to narrow it down to the relevant IP rights that you're talking about. So as you know, in Nigeria, we have at least the basic four. That's trademarks, patents, copyrights, and designs, right? There are other minor ones that are not as prominent as these four. But these four, they are the ones you get to work on a daily basis. So now when you talk of patent and designs, for example, you only get your right to, you can only say that you have a patent or you have an industrial design only when you have registered them. So you have to register to have a right. So there's nothing like maybe common law right or whatever. Now, when you come to copyrights, it will tell you, the law will tell you that you have the rights automatically vested in you as the author once your work is original and you have fixed it in a definite medium. You can decide to take the extra step of doing the copyright notification with the Nigerian Copyright Commission and you get a certificate, which is very fine. At least it helps you in case there is a matter in court. But the rider there is that certificate is not like it's a prima facie proof that you're the owner of the copyright, but not a conclusive proof, right? Then you now come to trademarks, where in principle, you say we are the first to file jurisdiction. So which means if you file your trademark, you own it. If A and B files and A filed first, A will own the trademark. Now, but aside that, you will find out that in practice, even from the law, Section 7 and the rest of them, Section 18 as well, that it doesn't end in you filing and registering your trademark for you to be deemed to be the owner. Because there are instances where you will file and then there is someone who is beneficially vested in the rights in that mark, or who has been using the mark even before you filed. And you find out that those other persons will have some rights to the use of that mark, even over you. At least the most recent example with this Domitila trademark thing, even though it's still in court, but the trademarks registry has gone ahead to nullify the registration of that trademark by Anne, because the registry found out that she did it in bad faith. She doesn't have a right to actually have filed that trademark in the first place. So these are like in a very brief way, how you can get entitled to your various IP rights. Now, we now move on to now ask, how do you protect them abroad? Because even from one of the questions the group sent, I saw a question like that, right? The general rule is that IP rights are territorial in nature. So when you have your trademark in Nigeria, it doesn't guarantee you protection in Ghana. Kenya, South Africa, US, and the rest of them. So for you to have your trademark rights in these other countries, you also have to go there and register your trademark. There is this Madrid protocol that tends to make it a bit easier for you to register your trademarks worldwide. Of course, so some of these multinationals like the Coca-Cola company, Amazon, HP, Apple, all of them, their operations are in so many countries, if not all the countries of the world, aside their home country where they originated from. So the law, member countries or member states, thought about it and say it will be a bit difficult for one to be going from one country to the other to, be filing these trademarks one after the other. Why not we create a system where you can file one trademark or, have an application and you'll be able to designate or have so many countries covered in your application. So they came up with the Madrid Protocol, which allows numerous, where you can file an application in one member state and designate so many other member countries, and the process will become a bit easier when you're now dealing with those other countries that you designated. Some will still require you to, still pay a fee and the rest of them. But Nigeria is not yet a party to that protocol. So you can't actually use that system in Nigeria. So even if you file in the US or whatever, and you need a trademark protection in Nigeria, statutory, you have to still file, get a trademark agent, file your trademark, prosecute it to the end, and get a certificate. Under patent, you also have a similar thing. Somebody can say, okay, it's filing a conventional application as opposed to non-conventional, which is just Nigeria. So you have what they call the Patent Cooperation Treaty, PCT, which allows you to file in an originating country or maybe the country of the applicant or the source, and then go ahead to designate some other countries where you can also register that your patent. Nigeria too, we do a hybrid, call it a hybrid enforcement of the PCT application, in the sense that we receive, but we cannot be we receive the applications filed in other countries and it is recognized. So somebody can file an application based on what has been filed elsewhere, claim priority, file it as a conventional trademark, we claim priority, the dates, everything, and the information will be filled, they are there. But you cannot start that process of filing a PCT application in Nigeria. So that's the issue. And it all stems from the fact that these laws have not been properly domesticated in Nigeria. Under designs, there is also the Hague Agreement that allows for a similar arrangement, but it's still not enforceable in Nigeria. Copyright, like I mentioned, is automatic. So copyright of foreigners are also protected. The law says as long as the country of origin of the person, person is from a country that has signed the treaty with Nigeria. Previously, it was not expressly. There were some issues in the past, even though the law for me is very clear as to the fact that foreign author can have his copyright protected in Nigeria. But there are some cases where the courts, I won't say misinterpreted, I would say made a requirement that I seriously think is not in the law. You have the case Microsoft and Franica, you have another case, the voice web case, and Imagine Technologies, where the court will always say, oh, because the law made a provision that the minister should make a declaration listing the countries that can actually enjoy that reciprocal protection of copyrights in Nigeria. In the absence of presenting such a declaration, that such foreigners will not enjoy reciprocity or reciprocal protection in Nigeria, which is actually not the real interpretation of that provision of the law. At least the law makes it a two-way thing, but the court gave it. And I think even NCC came out when the Microsoft decision was made to say that that is not the position of the law, as they will recognize foreign works that meet the requirements of the law. So that's basically for IP registration. Then for each of these ones, there are ways to do it. If you are filing your trademark, there is a way to do it. You file it. Now we use two models. You can either file it manually or you file it online. When you file, you get your acceptance. Before you file, actually, you have to consider a lot of things. Using trademark, for example, you have to consider if this your trademark is whether it's similar to an existing mark. Normally, what people do is to conduct a search. That search is not foolproof, I can tell you. You can conduct a search and they will tell you that this trademark is free, only for you to file it, and then later on, someone else opposes your mark and say, I already have the same trademark or a similar trademark in this same class. So you have to clear all these things, clear also the fact whether the trademark is morally right. There are instances where the registry and even the court has said, oh, we can't register this trademark you want to file because in relation to the goods you're going to use it, it's not morally right. There is a decision, for example, where the court refused to register a trademark called Deakin for alcohol. It has been registered in some other countries, but it was refused registration in Nigeria for not being morally, right. And so many other things. So when you have come up with a very good trademark, you go ahead to register and go ahead to file, go through the processes, including opposition. If you're successful, go ahead and pay for your certificate, and you get your certificate. It lasts for 7 years, after which you renew every 14 years. Similar process for patent and design. There are requirements, documents you need to bring. You file online, follow through. You can also file manually, follow through and get your certificate. Copyright, like I mentioned, is automatic. Now, when somebody now goes ahead to use that your trademark without your consent, or to commercialize your patent without your consent, or use your copyrighted work without your consent, that's where we now talk about infringement. Now, infringement of trademark, for example, can come in so many ways. You can use the exact trademarks. Let's say I file my trademark to Hussein, and you went ahead to use, I file my trademark Hussein for bottled water, for example, because you have to file a trademark in relation to certain goods and services. We have 45 classes of goods and services. So you have to select the one that applies to the business you're doing. So if I file my trademark Hussein for bottled water, and then Mr. B goes ahead to produce a bottled water using exactly that name, is infringing on my rights. Or he uses a name that is similar, very similar, that when you look at it, even without carefully looking at it, you may not notice a difference. He's infringing on my rights as well. So in that instance, you can sue the person for trademark infringement, even without having a registration. I said for trademarks, for example, you can have your rights under common law if you do not register. And then you can also have statutory rights if you register. So even if you do not register your trademark and somebody is using your trademark or trademark that is similar to it, you can still sue for passing off. The requirements for being successful under passing off is usually more cumbersome than being successful under an infringement suit. So that's why it's always advisable to register your trademark and not wait to sue for passing off. Similar thing applies to the others. I won't go ahead to repeat since because of time. And then when it comes down to enforcement, so it can either be an administrative enforcement or by the court. Now, administrative enforcement works especially for trademarks and copyrights. For trademarks, there are instances you can go to the tribunal. I just mentioned now that the domiciliary case is in court, but the producer's lawyers went ahead to file for a cancellation at the trademarks registry, and the ANTS trademark that is registered in 2020 was cancelled. So those are the administrative aspect of it. There are things you can do at the registry: opposition, cancellation, nullification, registration of the registry, and the rest. there are the ones you can do at the court, which are the infringement, passing off, and so on. Similar thing applies to the other IP rights that we noted. And on trademark aspect, when it comes to not just somebody using your mark, maybe somebody is using your mark, trademark to manufacture fake goods or the rest of them, then it goes just way beyond just infringement, or you can involve Standard Organization of Nigeria, you can involve NAFDAC, you can involve FCCPC, depending on the nature of the product that your nature of the product and the business that you're into. I will stop here, and then when it's time for questions, I will take the specific questions from the groups.
Thank you very much, Mr. Christian, for that wonderful talk on the topic. I will call on Ms. Rita to complete her talk before she went off. Ms. Rita, are you with us, please?
Yes, I apologies for that. My internet went off for a bit and I had to, restart. So I was talking about IP registration, and I listened to Christian talk about registrations as well, and the topic. So what I would like to say, I think my time is up, but I'll just close by saying, in relation to IP enforcement or registration. What? No, please. In relation to IP registration, like I stated in the beginning, that you have to identify what part of your intangible asset has commercial value. Then once you meet the basic requirements, you engage an IP firm or an IP agent to help you registration. Then when you're dealing with infringement, you have to verify that it's actually your work that has been infringed upon, the location as well, what is the amount that was, or the quality of work that was being infringed upon. So for copyright, under the new Copyright Act, I think is, I don't want to misquote now, but I think it should be section 20, where it talked about special exceptions, and where it was listed as to work that will not be considered to be an infringement, but fair dealing where it's for non-commercial purpose. Now, in order for you to determine whether that use actually falls within fair dealing, you now have the 4-factor principle that was introduced, which is kind of similar to the US 4-factor principle as well. So that is for the copyright aspect. For trademark aspects, is there a likelihood of confusion? Is it passing of what part of your trademark was actually being infringed on? Is it the logo, how it was placed, the color, the name, whatever it is? For design rights, you'll be looking at the visual appearance of that work in question, how similar it is to your work, and if it actually qualifies or can be considered to be new or novel. Then for patent, the functionality, basically, what is that technical thing that patent is solving? Are they improving on your already existing product out there? So I think one case I would like to draw attention to is the Fox Technology case against Facebook and Instagram, where the live streaming services was being infringed upon by Mark Zuckerberg's company, because they had reached out to the original creator of that tech to go into a collaboration. Documents were shared, and then at some point, negotiation broke down, only for Facebook to come up with their own Facebook Live and Instagram Live, and they had to sue. I think at the end of the day, they were awarded, I think it was $175 million as damages. For trade secret, basically, what did the person use that confidential information to do? How did he get access to it? And I will point our attention to this case that trended last year, the Coca-Cola case, where an former employee had shared certain confidential information that Coca-Cola used to preserve their drink and all of that. For plant variety, there's this case, trying to remember. So basically, the parties had gone into some sort of arrangement to use that particular species for a term of 5 years, and then it was later resold to some other person, and conversation came up as to whether that species was originated from the original person who planted it within that jurisdiction and all of that. For GI, we'll talk about where someone is mistagging the source of a product to a particular jurisdiction. For instance, you're seeing a lot of people classifying yogurt as Greek yogurt. When you hear Greek yogurt, do you think it's from Greece? When you hear champagne, do you think it's from a particular jurisdiction, or do you just think that champagne is affiliated to Nigerian brands? Basically, that's where the infringement will come in. Infringement basically is unauthorized use of someone's intangible asset without their consent, permission, or authorization. And one thing that I like about the new Copyright Act is that it hammers so much on you getting consent from the author. In an event where you're unable to, the commission will at some point step in to help you to do that. So I would advise the mentees who are actually on this program to take their time to go through the new Copyright Act. Then enforcement, oh yeah, and then infringement again, when you figure out whether that work actually belongs to you. Do you issue a cease and desist letter? Do you reach out to them to negotiate or get into some sort of licensing? Or do you go to court, or do you explore out of court settlement? That's on you. Then in terms of enforcement, what are those strategies that you've put in as an IP owner to actually protect your work? Are you monitoring use of your work within a particular territory? Do you have a software or tech that helps you to do all of that? Are you monitoring the registry to verify that no one is taking advantage of maybe a lapse, or someone just being a troll and wanting to commercialize certain aspects of your work that you may not have considered protecting? Are you opting to oppose? Are you trying to trigger a treaty? Are you collaborating with the customs? What exactly are those things that you are looking to put in place to make sure that you enforce your rights within that particular jurisdiction, or in a cross-border related IP situation? In conclusion, while IP may be considered to be a form of revenue generation for IP owners, it's very important that we as lawyers or IP owners who are actually on this platform should have a strategy, whether you want it to be a long-term project or a short-term project. IP is not supposed to be a short-term project anyways. Having the right team in place will also help you in terms of your valuation when you're trying to go into some sort of monetization projects, engaging the stakeholders as well, following up on development within your territory, and also identifying your industry. What are those provisions within your industry that you think when you engage and you have like a roundtable conversation, you'll be able to make a difference within your sector? And also finally retain the services of an IP lawyer or an IP consultant. So I guess that's it for me, and I'll just wait for questions and also listen to my fellow mentors on the program. Thank you.
Thank you very much, Ms. Rita. We're happy you were able to come back on the call and complete your talk on the topic for today. We don't have Mr. Mark here with us yet. We hope he joins before the call ends. I'll be calling on the third mentor for today, Ms. Shukrat Musa. Miss Amosa, please, are you on the call? Can you hear me?
Yes, I can. Can you hear me?
Yes.
Okay. So I think I have prepared something. Let me share my slide. Okay. Let me know if you can see my slide.
Yes, we can see your slide now.
All right. So I won't be doing much because my other mentors have spoken very well. So I'm just going to just say a brief thing about the topic for today. So we are discussing about IP registration, infringement, and enforcement, right? So what the law has joined together, let no man put asunder. You have your registration and you have your enforcement. Whatever it is you register, as long as somebody is infringing on it, there has to be an enforcement, right? So the infringement is that person that is coming in between while you have your registration and enforcement holding each other. Okay, so let's dive into it. So we have to discuss registration first, because without registration, there can be infringement and there can be enforcement. So there has to be something you have to register. So the overview is basically IP overview, IP registration, IP infringement, and IP enforcement. So let's go to IP overview, intellectual property overview. So the idea about intellectual property is you have to like create something. IP is the creation of human mind. It's something that you have created. But before you can have an IP, you must have created something. There's no IP without creation, right? So the first thing you have to do is have an idea of what exactly it is you want to do, or what exactly it is that IP is. So that idea now, when you now create that idea, that is when you now have an IP. The idea itself is not an intellectual property, because IP doesn't protect idea. It doesn't protect abstract idea until you have something tangible that you can show off that you've created. So this idea transforms into something that you've created. Now, when you create it, what do you have to do? The next thing you have to do is you have to register it. Now, registration is not compulsory for all types of intellectual property. For example, copyright doesn't require registration. Like, it's not compulsory, but it is necessary, right? While other types of IP requires registration, even if they are not registered. For example, you can still use the passing of, like, fall under passing of to actually protect your IP. But like we said, registration is just the best bet. So now you've now registered this IP. What next do you have to do? Now, after registering your IP, you have to police your IP, because nobody is going to do that work for you. You are your own police, except you want to employ somebody to now start policing your brand or your IP for you, then that's fine. But you are your own police, you are your first police. Now you've policed your idea to some extent that you've now found somebody that is infringing on your idea. When you found someone that is infringing on your idea, what next do? You have to enforce your rights. Do you understand? So you cannot just enforce what you've not created or what you've not registered. So that's how it boils down to the same IPsec that we have: idea, create, register. Then police. Why policing? Definitely you come across somebody that is using something similar or something confusingly similar to your brand, right? So once you now get that person that is infringing on your right, you have to enforce your rights. Now you've enforced your right. What next do? You have to monetize it. It shouldn't stop at enforcement. Like, IP is not what's that thing we say now? IP is not an end, it's a means to an end. It is not the end itself, right? You have to monetize your IP. So how do you monetize? You can license it, you can franchise, you can co-brand, you can sell it outrightly. You can do different things to actually monetize your IP. Okay. So now when you monetize, what else do you have to do? You have to, if it's an invention, you have to work your invention. Because what's the essence of getting 20 years for a patent right when
Can you all hear Miss Amosa, please? Can anyone?
No, she has gone off.
Okay, I think she's having network issues, so we just jump to our mentee's presentation. Group one presenter, please, are you ready with your slides for your presentation? Group one presenter.
Yes, I'm ready.
Okay, please, you can start now. Tell you know that you have 10 minutes for your presentation.
Please, can you see my slide?
Yes, we can see your slides.
This is one presentation, power presentation. And my name is Jiipcc Linda Akuna. So on our topic says IP registration, national, regional, and international registration. So moving on, I'll start by telling us what IP is. Intellectual property is just the creation of the human mind. Yes, and this form of IP includes patent, copyright, and trademark, as well as industrial design, etc. So we'll start by I'll start by telling what the importance of IP registration. So IP registration gives you a over order. Yes, having your IP registered, you enjoy that particular right that accrues to each class of intellectual property. Yeah, so I'll start by the registration of IP here in Nigeria, that's national. So the registration of IP is usually required under the Nigerian law in order to enjoy the particular rights that accrue to each class of intellectual property. So starting as the Copyright Act, Trademark Act, and the Patent and Design Act make provision on this requirement for registration. So moving on, we start with that of the trademark registration here in Nigeria. So a trademark is any word, name, symbol, or design, or any combination thereof used to identify and distinguish the goods of one manufacturer or seller from those of another. Yes. So the requirements for trademark registration include words and logos trademark. 2 is the applicant's name. 3 is the applicant's address. Then 4 is the applicant's email and phone number. Then the power of attorney. Yes. So the next one is the procedure for registration of trademark in Nigeria. There are so many procedures, stages you have to go through in order to register your trademark. So now, before its availability starts, here, this is the first stage in trademark registration in Nigeria. This is to conduct a search at a specific class. The trademark is supposed to be registered. Yes, you know the specific class the trademark is meant to be registered. The second one is the application. After the successful search, the trademark can then be filed. Here, you make the application. The program is acceptance. The trademark is to be examined upon filing. If found to be registrable, it shall be duly registered, and the acceptance letter shall be given to the owner. Also, now, the last one is the certification. Here, the collection of the certificate, the owner will be certified that yes, completed the registration. You are now the full owner of this intellectual property. Now, going on is the patent registration under Nigeria. There is now under patent. Here, a patent is an exclusive right granted for an invention that gives the owner the right to exclude others from making, using, or selling an invention for a limited period of years. Sorry. Yeah. So here is it. And then the following is the criteria for registration of trademark in Nigeria. Please, are you following, please?
Yes, we are following.
Okay. Okay, yeah. So now is we have to talk about like the criteria under patent for the registration of patents in Nigeria. And first, that it must be a novel invention. Yes, the second one is that it must be capable of industrial application, and the third one is must meet public policy and morality. And next is the procedure for registration of patents in Nigeria. Number one is availability tax, which I've explained. Yes, in that particular case, the tax has to be conducted to know the particular class has to register. And the next one is the application, which contains a description of the invention, and B, a claim or claim, and C, the payment of a prescribed fee, and D, a declaration by the inventor. And C, a power of action. Here, a power of action is used when this is the owner is applying or it was submitted by an agent. So going on, the next one is industrial design. Yes, industrial design, as we all know, is any combination of lines or colors or both or any three-dimensional form, whether or not associated with color. Yes, industrial design has to do with the appearance of a product. So now has to do with the requirements for industrial design registration, and they include the registration request to the applicant's full name and address, a statement of the design, an indication of the kind or class product for which the design will be used, a prescribed certificate fee, the signed power of action where the application is done by an agent, and then also where it is made by the two creator, a declaration signed by the creator requesting his name to be included in the register of design. And going on is the procedure for industrial design registration. First is the application, then followed by the approval. And the next is the copyright infringement. Yes, now other copyright infringement in Nigeria, we start by saying that a copyright is exclusive right granted to the creator of an original work to reproduce, modify, to distribute, and perform his work. And it is worthy of note that in Nigeria, registration of trademark is not a precondition to protection. Yes, once you have your invention, once you have your what you created, it's not a precondition. Registration is not a precondition to protection. However, registration of copyright governed by Copyright Act 2022, while the Nigerian Copyright Commission (NCC) is responsible for its registration. Yes. So, and then the requirements for the copyright registration include an application. This must contain particulars of work being registered, owner's name, address, telephone number, and email address, type of work, title of work, years of publication, first publication country, dates and years of registration, then years of creation, particulars of author, include the full name, last name, address, telephone number, email address of them. So going on, now we are now under the regional registration of IP. Yes, under the regional registration, there are two recognized organizations that handle registration of IP in Nigeria, in Africa, and they include number one is Organization African de la Propriété Intellectuelle, that's OAPI. This is an IP organization who has its headquarters in Yaoundé, Cameroon. It was amended. It was created in 1977 by virtue of the Banking Agreement. It was later amended in 1999. There are 17 members here. Only 17 states are signatories to registration of IP in Africa. So the second one is the African Regional Intellectual Property Organization, popularly known as AROPO. AROPO was founded in 1973 by virtue of the Lusaka Agreement. It seeks development and protection of IP rights in all of its member states. Yes, and it's worthy of note that Nigeria is not a member of either organization, but is a member is a member state of ECOWAS Regional Agreement, as well as the AFCFTA, that which means African Continental Free Trade Area, which includes a protocol on IT rights that aims to advance the effective protection and promotion of IP rights in Africa. So moving on, we have the IP registration, that international IP registration. And here we say that IP registration of IP under the international space concerns conventions, treaties, which have been developed to establish obligations for treaty member countries to adhere and to implement in their nation. Yes, they have a common uniform way how it can be registered to avoid doing registration. And under IP, we have under copyright, we have different conventions and tests that have been held in that regard. And number one is the UN Convention for Protection of Literary and Artistic Work, which was in 1886. And the second one is the Universal Copyright Convention held in Geneva in 1952. And the third is the Agreement on Trade-Related Aspects of Intellectual Property Rights, copyright rights. And the next is the World Intellectual Property Organization Copyright Treaty, popularly known as the WIPO Copyright Treaty or the WCT. And the next is the Marrakesh Jiipcc, and others include the International Convention for the Protection of Performance, producers of the phonogram and broadcasting organization held in Rome 1961. And the next is the WIPO Performance and Phonogram Treaty, that's the WCPC, held in Geneva 1992. And the next is the Berlin Treaty on Audiovisual Performance, CCAP or Berlin Treaty, otherwise called, held in two spots. Also, under trademark, we have under trademark convention that are held that regards to the WIPO Magic System for International Trademark, held in the year 1989. The next is Trademark Law Treaty, PLC, held in 1994. And then the Singapore Treaty on the Law of Trademark, SPLC, held in 2000. And under patent, we have the Patent Corporation Treaty, PCT, 1970. And the next is Budapest Treaty on the International Recognition of the Deposit of Microorganisms for the purpose of patent protection, 1977. The next is the Peace Agreement. Also, following is the industrial design. Also, you don't know that as a general rule and in accordance with the Paris Convention, industrial design protection is territorial. Yes, it is restricted to a specific geographical area or territory. And however, reference must be made to the hub system for the international registration of industrial design in 1925. It provides a practical business solution for registering up to 100 design events in each country by filing a single international application in one language, with one set of fees. And also, the body of Nigeria is not one of the contracting parties. So, this is the end of the one presentation. Thank you so much for listening. I remain Linda Jiipcc. Thank you.
Thank you very much for that presentation on behalf of your teammates. Please, what's your name? I can see the name of your phone on your Zoom, so you've not edited it.
Okay, I'm Jiipcc Linda Akuna.
Okay, thank you very much. I'll be calling on the next presenter to make her presentation before we continue from where Ms. Amosa stopped. So, presenter, group 2 presenter, please kindly unmute yourself and share your slides. You have to kindly note that you have 10 minutes for your presentation.
Good evening, everyone.
Good evening.
Sorry, I can't share my screen because her screen is still on share. Okay.
Okay, I think we have stopped sharing our screen.
Yeah. Please, can you guys see my screen?
Yes.
Okay. Good evening. So I'll be speaking on IP, intellectual property infringement and enforcement. So as we all know, in as much as we have this intellectual property rights, such as the copyright right, the copyright right, patent right, industrial design, and all of that, there are also people who want to infringe on these rights. So which is why this topic is here. So first, we'll be talking on what exactly is IP infringement. IP rights are infringed when a person, without the permission of the owner of such rights, exercises the exclusive right of the patent owner or authorizes another to do so. This is when someone that does not have right to a particular product makes use of that particular product. Like now, when we talk about trademark, like the name of your company, when someone else takes the name of your company as his or her own name, the person has infringed on your intellectual property rights. Or when they use a content in your book, if you're an author, the person has also infringed on your copyright. So the next point is the types of intellectual property infringement. Like as we have all the intellectual property rights, we also have infringement for all of them, as I stated earlier. So we have copyright infringement, we have patent infringement, we have design infringement, and trademark infringement. Copyright infringement, since copyright has to do with your written works, like for authors, if a particular part of your book, if a write-up in your book is taken out by someone else without your license, the person has infringed on your copyright. The same thing goes to your patent design, your design infringement, or your trademark. Trademark is like the design of your logo. When someone else uses that logo for his or her own company, the person has infringed on your trademark right. So we have remedies for this intellectual property infringement. What can you do when your right has been infringed? We have the cease and desist letter. We have the mediation option when an official mediator is hired for the case. We have bringing a claim to court. That is when you go through the litigation process when your IP is infringed. The remedies thus made available by the court would include but not be limited to. Now, this court, like what can the court give as a judgment when your IP has been infringed? We have injunction, damages, order to account of service, and tracing orders. So now we're looking at one of the most popular cases in intellectual property rights infringement. We have Apple versus Samsung over Samsung patent. So I'll be stating the facts of this case. It's in 2011, Apple filed a lawsuit against Samsung in the United States, alleging that Samsung had infringed on several of Apple's Samsung smartphone patents. Specifically, Apple claimed that Samsung had copied the design and functionality of its iPhone and iPad. So in this case, Apple filed a suit, like Apple smartphone, we have iPhone and all of that, filed a suit that Samsung was making use of its design pattern, like a part of its phone. Samsung was making use of that design in their own phone. So that was basically what the whole case was all about, more like patent infringement. Yeah. Then Apple claimed that Samsung had copied the design and functionality of its iPhone and iPad, as I stated earlier. Then the next year, in 2012, a US jury found that Samsung had indeed infringed on several of Apple's patents and awarded Apple over $1 billion in damages. So when the case was taken to court in 2012, which was the next year, the judge found out that Samsung had indeed actually infringed on Apple's patent. Like they actually made use of Apple's smartphone designs in their own product. So in 2016, and Apple was awarded over $1 billion for damages. Remember I said that the remedies could be injunction or damages, sorry. In 2016, the Supreme Court overturned the decision given by the lower court. So another case we're dealing on is Tesco and ILDL. Right? So in 2023, it's 19th April, 2023, which is this year, the High Court ruled that Tesco's club card logo infringed trademark of its rival, Lidl. So in this case, it's more like, since Apple and Samsung's case was patent, this case has to do with trademark. They said that Tesco was making use of Lidl's trademark. Like they had similar trademark designs, which was more like they were infringing on the uniqueness of their logo. Yeah. So Tesco plans to appeal against the ruling, as well as seek permission to continue using the logo pending the conclusion of the appeal. So when I read on this case online, it was actually found that Tesco was wrong. So now Tesco has gone back to court to appeal, the Court of Appeal, to make an appeal, so that they can continue using the logo while the case is pending. Yeah. So IP, intellectual property enforcement. Yeah. The law governing the enforcement of intellectual property rights and protection in Nigeria are codified in various statutes. So this particular slide is talking about the statutes where you can find laws relating to intellectual property rights. So we have the Trademark Act, the Patent and Design Act, the Copyright Act, the Federal High Court Civil Procedural Rule, and the Cyber Crime Act of 2015. So jurisdiction of courts to enforce intellectual property rights. This slide talks about which court has the jurisdiction to enforce intellectual property rights. The Federal High Court of Nigeria has the jurisdiction to entertain intellectual property rights cases. This could be seen in section 251 sub 1 sub F of the Constitution of the Federal Republic of Nigeria, which states that the Federal High Court has the right to entertain intellectual property cases such as trademark cases, patent cases, and the rest. It's also stated in section 7 sub 1 CII of the Federal High Court Act. So I'm done with my presentation. Thank you for listening. I'm done.
Thank you very much. I'll be calling on Ms. Ambosa before I do that. I'm encouraging everyone to put on their videos. We'll be taking a quick screenshot of Sorry about that. She didn't mute herself. So please smile for the camera while I'm taking the screenshots of our meeting. Thank you very much as you do so. Mr. Christian. Amina Adam, please, you can put on your video. Thank you.
Videos.
Okay, it's over to you, Ms. Shukrat Ambosa. You are to complete your presentation and also comment on the mentee's presentation.
All right. I hope my network won't disappoint me this time around.
Okay.
Okay. So I'm sharing my slide again. Okay. Can you see my slide now?
Yes. Yes, we can see your slide.
Okay. Good. So when we go to types of intellectual property, like what are the types of intellectual property? We have copyright, patents, trademark, industrial design, and trade secrets, right? So let's go to IP registration now. Like I said, you need to create your IP before you can actually register it. So now IP registration, idea will always come, but even if it's a stupid idea, it can never sell. Like most of the stupid ideas are the ones that are selling now, right? But there can't be registration or protection of idea without expressing the idea. Now, how do you go about registration? So just like Mr. Christian said, there are 3 routes to registration. We have the national route, we have the regional route, and we have the international route. So for national route is when you register in your own country. That's not national, it's just limited to your country alone. Now, if you want to register, probably you are doing business in Nigeria, but you want to export abroad, or you want to export to other African countries, you can now go via the regional route. So under the regional route, we have 3 regional routes. We have the EU IPO, that's for the European Union Intellectual Property Office. We have the ARIPO, African Regional Intellectual Property Office, and we have OAPI. OAPI is for the French-speaking African countries, okay? So under these 3 regional routes, you now have different member countries or member states under each regional route. But unfortunately, Nigeria is not a member state to ARIPO, so we can't actually file regionally. What we have to do is, if you want to get your IP registered in any of those countries, in other African countries, you have to go there and file nationally. Like you have to go there and file in their countries. Let's now assume Nigeria is a member state of ARIPO. All we have to do is just file one single application and designate the countries you would like to your marks be protected in, or your patent, or whatever it is. Do you get? But since you are not a member, you have to like go to each country individually to actually register your interest. Now, when we now see we now register in ARIPO, the same goes with OAPI as well. It's for French-speaking countries. But if you don't want to go the regional route, what else can you do? You can go via the international route. And when it comes to international routes, we have different routes. Now, for trademark, you go to the Madrid system. For patent, you go to the PCT, Patent Protection Treaty. For industrial design, you go through the Hague. And for copyright, we all know it's Berne Convention, right? Even though the Berne Convention says that as long as you are a member of the Berne Convention, you necessarily don't have to register your trademark, your copyright. So whatever you have in Nigeria is supposed to be automatically protected in each member state of the Berne Convention. But the Berne Convention has made it open for these member states to now decide if there will be registration in their countries or not. For example, in the US, you can't claim damages if you've not registered your copyright. So that's what this IP registration in those 3 routes does. So it's now left for you to determine which country exactly do you want to register in and which routes you would like to take to register those rights. So like we know, Nigeria adopt the first to file instead of the first to invent, right? So in Nigeria, if you don't file first, you have that there's this probability of you losing your rights, just like Mr. Christian said, this domiciliar issue. Unfortunately for Zeb, Anne filed the trademark, even though we know that she filed it in bad faith. But fortunately for him, again, he won the case because he didn't file his trademark, that he was using the passing of kind of to defend himself, but indeed filed. But because Anne filed first, then she was the one to like take him to court for trademark infringement. So anybody that filed first has an upper hand against someone that didn't file at all. Then so the next one I talk about will be, sorry. So have you heard of poor man's patent or poor man's trademark? These are just like poor man's trademark is the same thing as unregistered trademark, like a trademark that you did not register, just like now use like the passing off now. Then for poor man's patents, back then, people don't used to register their patents. All they'll just do is they are going to mail themselves a copy of whatever it is they've done instead of going through the registration route. But now we now realize that doing that does not actually give us a good right or give us a standing right to actually prove infringement and the likes. So that's not like registering their copyright, registering their patent, their trademark, and the like. So if you don't have a registered trademark, they'll call your trademark a poor man's trademark because you didn't already register it, it's just there. So what are the duration periods for protection? For trademark, initially it is 7 years, then 14 years consecutively. But because as long as you are using your trademark, you are maintaining it and you are renewing it, then it can last you indefinitely. That's why we have indefinitely here. For copyrights, copyright is dependent on the type of work. For example, as literary and artistic work is protected throughout the life of the author and 70 years after the death of the author. For example, sound recording, photograph, they're protected 50 years from the date of production or from the date you capture the image. It depends on the kind of right you're protecting. Then for patent is 20 years, like it's 20 years everywhere. However, there are some field or industry that they are likely to get some additional years, like pharmacy, because before they go for testing and so on and so forth, the time would have lapsed. So they give them kind of 2-3 years extra. I think the maximum is 25 years, but generally everywhere is 20 years. Then for industrial design is protected for 5 years initially, then 5, that's 10 years. So altogether is 15 years. So 5 years first, then 2 5 years again consecutively, making 50 years altogether. After 15 years, your industrial design goes to public domain and anybody can use it. After 20 years, your patent goes to public domain, anybody can use it. After 70 years, after the death of the author, your copyright goes to public domain, everybody can use it. But your trademark does not go to public domain as long as you are maintaining it and you are paying for your renewal. Then for trade secrets, you just have to keep quiet and know how to protect your trade secrets. So when it comes to infringement, just like the second speaker said, infringement refers to unauthorized use, reproduction, license of the creation of somebody's mind. So now you see this image here. We have somebody that's trying to create an idea, right? And the second image is just trying to peep to see whatever it is that person is doing so they can go ahead to now work on it. Then you can see the third image, somebody is just trying to pick up the person from where he's stealing from and like, oh, now I've caught you today, you can't go with my intellectual property rights, just like that, you understand? And you see the next dragging themselves. Oh, let me see. Okay, let's just discuss this aspect now. So what's the difference between infringement and passing off? So you see sometimes some people will say this person infringed on my mark. Some people will say this person passed off my mark. So on the Z case, when you read it on those websites, you see they're going to write, is it? No, not the Z case now. I think it's the Olympic milk case with the IOC. Not Olympic, Olympic milk was passing off and was infringing, but I don't think you can't be passing off and be infringing, right? You only use passing off for a mark that has not been registered. That's your poor man's trademark. And you use infringement for a mark that has been registered. So you can't infringe a mark that has not been registered. You can only pass off a mark that has not been registered, but you infringe on a mark that has been registered. So that's the difference between registered IP and unregistered IP, right? So let's now go to IP enforcement. How do you enforce your rights? IP enforcement refers to the act of putting measures in place to against the usage of your intellectual property without your permission. So why do you have to enforce your rights, or how do you enforce your rights? So now you've created an idea, yeah, like it took you like 3 months, 1 year, 2 years to actually come up with something tangible that can be protected by by intellectual property. But you can now see somebody here trying to take your idea just like that. And this person now is now trying to enforce his right, because when you don't enforce it, the person just goes away with your right. And the thing is, when you don't enforce your right, you say without your permission. So enforcement is very important. So yeah, we can see this person probably wants to enforce his rights. He has called on the police, and the police is not trying to chase this person that is trying to take the right, the IP right. And you can see here they've caught the person and taken the person to court, or whatever means they want to settle it. It could be ADR, it could be mediation. So now, how do you enforce your IP rights? Now, I think it was Rita that mentioned, before you enforce your right, you need to know, has there been an infringement, or do you even have a right in the first place? Like there are some exceptions, like fair use, when the blind uses your work. So you need to know if you actually infringed, or if your work has actually been infringed on before you can say you want to enforce. Okay, so in some cases now, some people don't even have a right in the first place, but they will say you've infringed on your rights. So what do you want to enforce actually? Are you going to enforce a right that you don't even have in the first place? So it is very important for you to consult an IP consultant or an IP lawyer to be sure your right has actually been infringed. Now, the next thing you have to do is to get a lawyer to draft a cease and desist letter on your behalf so as to send to that infringer. When you now notice that this person is not even replying or is not doing anything about the infringement, you can actually raise a takedown order on different social media platforms. Even the Copyright Act said that, as it's in one of the pages, they can actually use takedown order to take down your rights from somebody's page. And even the Copyright Commission has that power to take down infringing work on website as well. If that doesn't work, then you can actually file a lawsuit if you can afford it. If that doesn't work, you can settle out of court, or you can go via the mediation or arbitration route. One way or the other, just make sure you are enforcing your rights. I understand that some people are like, court case takes long, blah, 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 but try, at least let it even be in that process. But if you can't go to court, like I said, try as much as possible to, find your way around it and make sure the person knows that you've actually infringed. See, we can't blame some people sometimes because people don't know. People don't know there's something called intellectual property. I want to talk of infringement on your rights. Some people don't know, and some people know. So no matter what, no matter small, big infringement, try as much as possible to enforce your rights. So I think that's all. If we talk about the first slide, my network went off kind of, so I didn't really get the slide from the beginning. But I noticed the place she was talking about criteria for patentability, and she missed inventive step. Inventive step is one of the criteria for patentability. We have novelty. The work has to be novel. It has to be industrially applicable. It should be inventive. So that part where she added, it should not violate public morality. Yes, it shouldn't, but it is not one of the major criteria for patentability. So it should be inventive step before you can now think about patentability. That's just what I cited in that other one. The second one, I'm not sure I saw much. I'm not sure I saw much reference.
Okay. I think your voice was breaking at the end, but you said you didn't see much on the second one, right?
Yeah, the second slide, because it was a bit tiny. So I was trying as much as possible to see. But maybe if we have questions, I'll take it from there.
All right. I'll call on Mr. Christian to also contribute and give any comment he has on the both presentation from our mentees.
Hi, sorry. So I will just go ahead and answer the questions I saw from this that were sent to me. Just a minute, trying to open.
Sorry, sir. I think you have to comment first before we go to the question and answer session. For the question, I think I'll be asking the question, then you'll be answering. That's how.
Can't we front load the comment given the original? Because it's basically the same thing. I looked at the slides and I also listened to the presenters, and I think it tallies with basically what I gave during my intro, right? And in fact, they even did well because I think the group 1 or group 2 even went ahead to go more practical when we are talking about the remedies, how you go about it, starting from the cease and desist letter down to if you can mediate and then go to court and the rest. But the only comment I would just have to add there, right, is when during enforcement, right, the model, going by what cease and desist letter down to trying to negotiate or do a mediation, arbitration, or whatever before going to court. Yeah, that's fine. That's usually the process. But there are times you may not need to do cease and desist at first because of the nature of the matter. Now, for example, if you're going to court, for example, one of the things you can be asking for is what we call an order for anti-impailer injunction, right? So if you're going to ask for this order, then you find out that you can't be issuing cease and desist letter to the person because you probably just be alerting the person as to what you want to do. Most times, if one of the things that anti-pillar injunction helps to solve is if you know that this person is infringing on your rights, or the person is carrying out some activities that are potentially infringing on your rights, but you do not have sufficient evidence. Because, for example, if you go to court and say that this person is using a trademark or a product package that looks like my own, the court would like to see the two products side by side and compare the feature, compare the name and everything. Now, if you don't have that evidence, you will need to get it from that person. And one of the ways you can get it from that person, if it is not readily available, is to get an anti-pillar injunction that will allow you to move into that person's premises and carry those products by force with the order of court. So in that kind of situation, you don't need to alert the person that you're coming, because if it's a very smart criminal in court, we deal with a lot of infringers who are smart criminals. Like there are people that their business in this life is to infringe on other people's trademark, and they set up the strategies from. In fact, some of them will have a 10-year plan on how to implement it, and it will work for them. So if you're dealing with such a person, then you have to go by way of this and do everything possible not to alert the person that you're coming. Because even sometimes we've had occasions where even after getting the anti-pillar injunction, before you execute, maybe maybe in the course of reporting to police, because police will have to go with you, or getting the bailiffs of court. Anyhow, maybe the information gets leaked. Then you find out that when you now get to the premises you're supposed to execute the injunction, find out that everything has been moved. You will meet an empty store or maybe warehouse or something. So it will all depend on the nature of the case for you to adopt the best, mode. So this letter is always fine mediation, because sometimes some matters actually get settled in that state without even going to court, especially for people that either didn't know that they were infringing, because there are occasions you find out that the person actually didn't know that what he's doing constitutes an infringement on someone else's rights. So when you write to the person will just come back and say, oh, I'm sorry, I didn't know, I'm going to stop it, or I'm going to change my product package and this and all that. So a lot of things end on that level. But the recalcitrant ones will as well go to court. And okay, maybe because the IP enforcement, some of the laws listed, there are so many other laws. I'm still looking at the group 2 listing presentation. There are so many other laws, like I even saw it from the question, the merchandise marks, that's a very very, very potent law that we use often in tackling trademark infringement, especially if you want to go to court or if you want to use the police for execution and the rest. And then initially I mentioned some of the agencies that you can also use. If you look at their laws, basically, they are not strictly IP laws, but what they do have an impact on IP. So using NAFDAC, for example, before you register a product with NAFDAC, you must have a trademark. Now, if somebody now goes ahead to register a product using a trademark that is similar to your own, and in enforcing that your right, you will find out that aside going to court or probably going to the trademark registry to cancel the trademark, you can also approach NAFDAC to say this person is using a trademark which is similar, because their law says you cannot use a trademark which is similar to another person's trademark, So you can be asking NAFDAC to revoke that registration. You can go to FCCPC, Federal Consumer Competition and Consumer Protection Commission. They have so many laws that say you cannot advertise your products or market your products or sell products in a way that is confusing to consumers or in a way that will deceive, confuse deceit and all those things. If someone is using a trademark that is similar to your own, even without going to court, you can approach FCCPC. So the thing is that there is no specific law, for example, especially when it comes to trademark enforcement, the anti-counterfeiting part. There is no specific law. So, but there are so many laws that have provisions that touch on it. So it depends on the situation. You can feel, can combine two or go for one. Sometimes we use SON, Standard Organization of Nigeria, instead of going to court and spending the whole time, oh, this person is committing trademark infringement. Just use SON if it's something that falls within their jurisdiction. So, on that aspect of the laws, also know that there are so many other agencies and laws you can apply. And group one, group one also went into details of trademark registration process, which is fine. I think somebody in that group must have registered a trademark for all the details that are required, and even the procedure from availability, search, application, and the rest. There is one procedure that we usually ignore, which is in the law. Even about, I won't blame you guys, because even in practice, we don't even do it. Is before availability search. It's not compulsory though, it's optional. The one that requires, if you feel, initially I mentioned that before, if you're choosing your trademark, there are things you have to consider. Make sure that it's not similar to an existing mark. Make sure that it's not contrary to morality and the rest of them. There's a provision in the law that allows you, if you're not sure whether this your trademark is good enough for registration or whether it will be accepted, you can approach the registrar for what they call a preliminary advice. That's actually, if you read, I think section 18 or so, that's actually the first step. But none of my clients have even done that. But it's something you can do. You ask for a preliminary advice, you send it to the registrar and as an application and say you pay a fee for that you want to register this trademark, but you're not sure whether it will fly, this and that. And the registrar will give you an advice to say, okay, this is fine or this is not fine. But that's not an acceptance, because when you file the trademark, it can still be refused, even though there are rules that if it's refused, then they will refund you the money you paid for the preliminary advice. But that's actually a very good one, but we don't usually use it in practice. But it's actually good. It will save you a lot of stress of having your mark refused for one of those either absolute reasons or the conditional ones. Right. And on copyright registration, I mentioned there is this case. I can't remember the name of the case now, but it has to do with something that touches on both copyright and patents, where the court actually had the opportunity to discuss the effects of the copyright registration that we do, especially with regard to the certificate. And at the end of the analysis, the court made it clear, as I mentioned before, that the certificate is just more like a prima facie evidence. Because when you've gone through all the process of registering your copyrights and you have a certificate, and then somebody can come out and prove that he produced that work before you, the person will take precedence. That your certificate will be nullified, and the person that has a proof of ownership of the copyright will take precedence. So I will stop here with the comments and then wait for the questions.
All right, thank you very much, Mr. Christian, for that comment. I'll call on our last mentor for our comment, Ms. Rita.
Hi.
Yes, we can hear you, ma'am.
Sorry, my allergies are acting up, so I might turn off my mic at some point. But I'm not sure I really have much to contribute in terms of comments. I wouldn't want to start my video. I look messed up because of my lips. But basically, Mr. Christian already covered a lot when he was giving his review, same thing with the Quran. I guess for me, most times when I get the call from Jiipcc to participate in this, I kind of try to look at what the efforts that the mentees actually put in their own. So first of all, I would say kudos because based on their level of expertise and experience and knowledge, they did what they felt they should do. But this is an avenue for you to actually reach deep and see how far you can go and, you know, unravel the puzzle that you've been given. So for group one, I would say they didn't really put in so much effort. Like it was just straight to what is IP types of IP infringement. So other than listing, you know, the IP mechanism infringement, certain types of IP mechanisms have specific types of infringement. Then again, I would have considered listing disputes that may fall under infringement, instances where an IP owner had to invoke his or her rights, what kind of arrangement was it? Then when they talked about remedies for IP infringement, remedies for me would be solution and not talking about dispute resolution mechanism because it kind of merged both conversations together, which I felt wasn't right. Then they went straight to the case. So foreign cases, but no Nigerian case. I do understand that you want to give your research some sort of international flavor, but I would say in Nigeria and in Africa, we are having series of cases daily. We recently had the Olympic case, which Ms. Shukrat alluded to, the Olympic case as well. We also had the Airtel case this year, and a couple of other cases that I felt they should have reached out to. However, I like the fact that they made mention of the Tesco case, which came out last week and it's currently trending within the UK environment. Then just like Mr. Christian said, in terms of IP enforcement, the laws or what they listed there, they played it safe. So it doesn't show that you are creative enough in terms of your research. And we know for IP practitioners, you need to have good research skills at the end of the day to help you strategize, help your clients strategize and come up with the best possible advice at the end of the day. But kudos to group one, I think, no, group two. So moving on to group two, which talked about IP registration, they just delve right into the conversation of it, the national level, what is required, regional, international, and just wrapped it up there. I think there should have been some sort of merits and demerits where you give advice as to which form of IP registration would be best, in what instance, where you would want to opt for like a multi-layered registration, in-house or in-system administrative proactiveness, which Mr. Chris also alluded in terms of the preliminary advice that you also need to achieve or reach out to the registry for. Is it just applicable in Nigeria? Or I think again, if you're actually going to reference a foreign case, the Coachella case is a good example of that, where there's an opposition and the registry gives you some sort of timeline to come and defend that opposition that isn't there. So those kind of issues should have been raised within their presentation. Right of appeal in terms of registration when it doesn't go through because someone opposed it, or you kind of abandoned your registration because there was a complaint, or after registering, you decided not to use your IP. So that's for me how I would want to take my own presentation. I believe maybe you were given a certain number of timeline, but if you look at Miss Shukura's presentation, lots of pictures, and then you get to explain. So instead of jumping on multiple write-ups, maybe use more pictures and then do more explanations. That way, the judges or the mentors or whoever is listening to you can be able to follow through and see that you actually put in so much effort. That, but I would say you guys did a good job. Generally, basically for me, having a strategy is what helps me most times. Also understanding the business of what your client is doing or what the other party wants to do. Always be one step ahead of your client, and don't take it to heart if your client decides not to, use your services either for enforcement or registration. Also, the use of tech again will also help. That should have been included in terms of relation to infringement and enforcement. What are the gaps? What are the laps in terms of IP registration? I did not see Group 1 cover that. And I think Group 1's presentation was on registration. So that's about it for me. Any other question I will take, but I can't stay for long. So thank you.
Thank you very much, Ms. Rita, and our other mentors for the comments on our mentees' presentation. I believe they will we'll all take notes of your contribution and comments and make better presentation in the future. I'll be taking the question, but before I start with the question that was sent, I encourage any mentee that has questions to raise their hand or send your question to the chat box. So I'll call on you to either ask your question or I'll just read from the chat box. So the first question is for Ms. Rita. Is the Merchandise Act still relevant law for IP in Nigeria? Ms. Rita, you are supposed to take the first question. Ms. Rita, please, are you still with us?
Yes, sorry, I didn't get your question. Can you take that again?
Okay, the question is the Merchandise Act still relevant law for IP in Nigeria?
I think Mr. Christian answered that in passing when he was talking.
Okay.
So if we can skip that. Well, Mr. Chris already answered, yes, it's still very relevant. Though not popular, but it is very relevant.
Okay.
Same thing with the trademark regulation, which is not relevant. I'm not sure how many people actually are aware of that. Or just like what Mr. Christian said, I'll just go with what he said and just move on.
Okay, I'll just give you another question, which is, what is the process for authorizing a company or person to use your IP?
Process for authorization, it has to be in writing. It doesn't really matter the type of IP mechanism. So for instance, the copyright law provides that if it's an assignment or an exclusive agreement, an exclusive license, it has to be in writing, not orally. Whereas you have instances where people would have like handshake conversations, either one party is not signing or refusing to comply. So best thing first, investigate the chain of title, who actually owns the work, someone managing it, someone acting as the administrator, whatever it is, find out who owns it. That way you're able to prevent any kind of IP disputes that may arise in future and protect yourself and save some money at the end of the day. Once that is done, get your lawyers involved. I think you should get your lawyers involved from your investigation to when you figure that out to when you exchange documents. Then you decide the scope of your arrangement. Is it going to be an exclusive one? Or is it going to be non-exclusive? Is it limited to just Nigeria, or is it going to expand to 3 other locations? Then you also need to consider so let's talk about copyrighted work where you have to engage, say, a collective management organization. Now you are assigning your right to them for a certain, to help you collect your royalties, negotiate licenses on your behalf, basically do all of the things. You're parting with some of your rights, not all your rights. Once that is done, you determine your royalties in terms of either what is obtainable in the industry or what you feel is the right value for your product. Monitor how it's being used. Don't just give consent and then go and sit down. So I would say I would reference us to the Oyinka Owenu's case against iRockin, where she had given them, I think it was a 1 year or 2 years license to use her music on their platform. Contract terminated or elapsed, and they kept on using. She sued, and all she got was 500,000 naira as damages. And at that time, Jason was trolling her on Twitter that after everything, all she got was 500,000. But the person has enforced his right in terms of making sure that you do not use his or her eligible copyrighted work. Same thing with the Airtel case with Wale, where his images was to be used for 1 year for an Airtel advert, and he had relapsed. And so you then also need to consider the parties that are involved. Did you get it directly from the owner of the image, or the company that was tasked to manage the person's profile at that time? Just make sure that you dot all your I's and cross all your T's. And then you move on from there. I don't know if that answers your questions on what you basically need to do when you are trying to get authorization. But consent, very important. Doesn't matter the kind of IP you're discussing. Get consent, written permission or authorization. So I think for trademark, you also need to document in terms of your assignment and licenses, with notifying the registry that you have been assigned this mark for whatever term. If it's for compulsory license in relation to patents as well, the government will basically engage you, and you come to an agreement, the percentage of the royalties and all whatnot. So in conclusion, I would say mentees should read the law, especially the schedules that we don't really think have anything, because when you do that, you find out you're properly informed. But in practice, figure out who owns, get written agreements, monitor, get your payments. If you want to renew, but make sure that you have your moral rights are not infringed upon, or you don't transfer that so someone doesn't take advantage of your inability to either understand the terms of contracts or not knowing the extent of the rights that you actually have. And I'm done.
Thank you very much, Rita. I'm just going to read the questions on the chat box before we ask the other questions. So this question is for Mr. Christian. Okay, I made a trademark registration last year, but I was told that the registry does not issue certificates for now. If that's the position, and the acceptance letter suffice for a registered trademark.
Sorry, you said with the acceptance letter suffice as proof of a registered trademark. No, the acceptance letter is not the same as a registration certificate. The trademark is the trademark registry is not issuing certificates. It's just an internal problem, right? It doesn't change the rules or the law. If they're not issuing certificates, you have to wait till whenever they issue the certificate. So you have your RTF number. Your trademark does not qualify to be called a registered trademark until the certificate has been issued. If what you have is just an acceptance letter, especially when it has not been published in a journal, it's just that's just an acceptance of your application. It's not a legal right, so to say. It's more like an equitable right. There is this case where the court made that huge mistake. But unfortunately, that's I don't know whether they've gone on an appeal. I presume they are on appeal now. But unfortunately, that is the law because it's from the court of appeal. But that was a very huge mistake, and that's one thing you see when well, let's leave the judges so that we don't. But that was a huge mistake in the D&S trading case, D&S trading and Remia, where court said, oh, that one party has an acceptance letter and that is a loud statement to say that he owns the trademark and is in fact an equivalent of registration, that every other thing that is remaining is procedural or whatever. That is very, very untrue. Section 22 says, before your mark is registered, it has to pass through opposition. If your mark has not passed through opposition, there is you can't claim to have a legal right, because there is a very high possibility that at opposition, someone who has a similar trademark or an earlier right will oppose you, and then your mark will be refused. In fact, even without the opposition, the law even went ahead to say, apart from saying, if you read section 22, you see it has so many subsections. Apart from saying, oh, you must have gone through opposition and be successful, or maybe it was not opposed at all, then good for you. If you went ahead to now say, even after it has gone through opposition and you were successful, it wasn't opposed, but it has been published. If the mark was issued, accepted in error, it will still not be registered. So that shows you that the acceptance itself is not even a conclusive proof that you already own that trademark or that you have registered that trademark, because it can be accepted today and still be refused tomorrow before a certificate is issued. If they later discover, oh, like I've done some cases, so many cases where a mark that has been accepted and it may even have been published and even opposition may have passed or whatever, but you discover that, oh, the registry made a mistake in accepting this mark because at the time they accepted this mark, there is an existing trademark, similar trademark, or even the same trademark in the same class. The one I did most recently was for Facebook. There is an existing Facebook registration in the same class, and the trademark registry accepted something similar. So even when it was close, the opposition period that even passed, it was now close to issuing certificates with petition, and that acceptance was withdrawn. So both of them are not the same. Acceptance is just merely saying we have, because acceptance at the stage of acceptance, when you file a trademark, it goes through two levels of searches. Search one, which is the prior search, they will search through what's it called? The records to see the older application, the older trademarks that have been registered in that class to know if anyone is similar. If it's not, it will go through search two, which is where the examiner will look at the distinctiveness. Oh, is this mark distinctive or is it descriptive? Is it contrary to morality and the rest of them? If all those things are fine, they will not issue acceptance. That acceptance is just saying, we have accepted this trademark for registration. It's not saying it has been registered. Say we have accepted it to go through the process for registration. So the next thing will now be to publish it in a journal. The registry, they release journals. There is no time frame. So they release it whenever they have the money to release. This is a trademark journal. It's usually voluminous. See how big it is. They will release all the trademarks that have been filed over a period of time. They will publish it. They will publish it in the journal according to the classes. So, and whenever it is published, third parties have a period of 2 months to oppose. So if your mark is published, even though you have an acceptance and it is published, and somebody opposes and you lose, that's the end of the trademark for you. So always ensure to get and that is one, let me just even mention this one, that is one mistake some entrepreneurs do. If you are, for example, in the manufacturing sector, and you're manufacturing one of the things we call the regulated products, those are the products NAFDAC regulates, like soap, detergent, bottled water, food product, and the rest of them. One of the requirements for NAFDAC registration is that you will get a proof of your trademark registration. Now, because NAFDAC knows that waiting for trademark certificate can take too long, sometimes as much as 2 years plus, they now created a leeway by saying, okay, if you have your acceptance of trademark application, we will accept that as proof of trademark registration and register your product for you. Now, what some people now do is they will file a trademark. When they get the acceptance, they will use it and register for the NAFDAC thing, get their NAFDAC registration, and they will abandon the trademark at the registry. They don't know that the trademark will still go through that process of publication. And because we don't pay for publication in Nigeria, there are some jurisdictions, some countries where you pay before it is published. But in Nigeria, once it's accepted, it will go to publication. Now, it will go to publication. Somebody will now oppose. And maybe the agent you use is not an agent that maybe his work is not fully this IP thing. The agent is just, file and collect money. When it is opposed, they send the opposition to the agent will ignore and will not send to you, or they will send to you and you ignore. And the time frame for you to respond, the 1 month time frame for you to respond will pass. Then your trademark is cancelled. You will be carrying your NAFDAC certificate and your acceptance letter thinking you have a trademark, and you don't know that that trademark has been cancelled at the registry. And then that person can now take that ruling from the registry, then go to NAFDAC, say, this trademark that this person presented for registration has been cancelled. So cancel the NAFDAC registration as well. We've done such things in the past. The person will now come and be saying, I have a trademark. I tell which trademark? Trademark that has been cancelled since at the registry. So that's it. Both of them are not the same thing. They have exclusive purposes.
Thank you very much, Mr. Christian, for that eye-opening answer to that question. I think there is another question. Okay. There was asking, this question is from Ms. Amosa. Please, could we get the full citation for the Olympic case you mentioned?
Yes, I did. I already posted it in the chat.
Okay, thank
In
you.
the chat
So
box, you can check.
you can also take the next question again. Can a foreign company or individual register intellectual property in Nigeria?
Can a foreign company?
Or do they need to be based in the country? Can a foreign company or individual register intellectual property in Nigeria, or do they need to from abroad, or do they need to be in the country?
No, you don't need to be in the country. You can register in Nigeria. As long as you have registration, says registration at the ministry, maybe trademark or copyright. You have registration. You don't have to be based in Nigeria before you can register. However, if you want to register on behalf of your company, like you want your company to own the registration, probably you might have to register like a company registration. They now use that company trademark registration to now register as the owner, or maybe the trademark you're filing, or the patent, or the industrial design.
Thank you very much, Ma, for that answer. The next question is for Miss Rita. I don't know if she's still with us. Okay, yeah, she's still here. So, can IP be registered in multiple countries at once? Miss Rita, please, did you get the question? I don't think she's still with us, because she's not responding. So, Ms. Amusa, you can answer the question.
Okay, the question was if you can register intellectual property where?
Can IP be registered in multiple countries at once?
Yes, it can, and that's why I talked about the rights earlier. The routes. So you can go through the regional routes. For example, if you want to register a trademark or a patent in ARIPO, that's the African countries, right? You have to go through the ARIPO route to register. But because Nigeria is not a member of ARIPO, you can't register like that. You have to go to the country and register individually. Also, ARIPO operate the unitary, they don't operate the unitary system. That is, when you file in ARIPO, it doesn't cover all member states in ARIPO. However, EU IPO and OAP operate a unitary system. So when you file in EU IPO or when you file in OAP, it covers all the countries. Do you understand? But ARIPO, you have to designate that, okay, I pick this country, I pick this country, I pick this country. However, for Madrid, which is the international system for trademark, when you file Madrid, you also have to designate each of the countries you want to file in. So if your trademark strategy is looking at filing in ARIPO and also filing in abroad, you don't have to file regional first and file international. You can just file international and pick regional and also pick the individual international countries you like to file in. But you have to be a member state, or maybe you are residing in that country before you can actually file for Madrid. But Nigeria is not a member of Madrid. We are not a member of ARIPO. So the only way you can do it is to go through those countries and register individually in those countries. But if you are a member of ARIPO, you are a member of Madrid, you are a member of Hague, you can file once in your country and just designate the countries you want to register in. So that system will now proceed and send your application to those countries individually before they now check it and now apply, maybe grant it or not, depending on their law. So there's no assurance that, okay, fine, because my trademark is registered in Nigeria, that means they'll register it automatically in the US. No, they have their own laws. So if you don't meet up with their registration criteria, they are not going to accept it. So your registration is dependent on each jurisdiction. The laws of each jurisdiction is not automatic. So that's what I'm going to say.
Thank you very much, Ms. Amusa Shukurat. I think we'll be taking the last question for Mr. Christian before we take the closing remark from Mr. Joseph Obo. So how will a company be able to recover accounts of profits from another company that has infringed on its copyright? This question is for Mr. Christian.
So the practical way we do this, because it will be nearly impossible for you to get the exact records as to accounts of profits. That word or that remedy is actually meant to, reimburse you the profits the person has made while using your work or, illegally using your work. But what they usually do in practice, at least one of the cases we did at Federal High Court is that's what we call inquiry as to damages. So you look at the records, say when you are exploiting that work yourselves, they look at the records, produce the records before the court and say this is how the profits flow, this is how the income flow within a space of, let's say, 1 year. So on the average, this is what it should be. Now, this is the period why this person has done something that inhibits your exploitation of that work. So your profit have gone down because of this other person's activities. So the margin, oh, this is what you're supposed to make, and this is what you now made because that person did something that we did at the Federal High Court. But in real sense, what it's meant to be is the person gets his own books. They look at it and see the actual sales and profits, and he will pay back that money to the owner of the work. That's normally what it should be.
Thank you very much, Mr. Christian. Thank you very much, Ms. Amusa, and also Ms. Rita. I'll call on Mr. Joseph to give us the closing remark for today's session. Mr. Joseph, please, if you are still on the call with us.
Yeah, sorry, my apologies. Well, today for me, even as a legal practitioner with a lot of years of experience, I can say that I've picked up so much from what Mr. Christian had to say, and of course, as well as what Amosa also had to share. It's been quite enlightening for me personally. Also, our third mentor, I don't think she's still on the call. I really want to say a very big thank you to all our mentors and for the mentees, for the research, for the teamwork, for the resilience, for the dedication to ensuring that you participate in the program. I think basically you are building character, and that character is important for the next step or for the next level in your professional development. So thank you to everyone that made today's session a success. I've had a very great time. I would advise that there might be certain things that you thought you heard initially. Go back, listen to this video over and over and over again. You know, there is no limit to knowledge, but you know, knowledge, you need to invest time for you to really come up to speed in terms of having to get the nitty-gritty of the issues and the reason why certain statements have been made by our mentors, the reason for certain things, especially in terms of infringement of trademarks and everything with respect to the entire value chain of trademark registration. So it's a big thank you, Mr. Hussein. Thank you so much. Amina, thanks a lot to all our mentees and mentors. Do have a very wonderful weekend. And hopefully, by the grace of God, next week we'll be up again. Thank you.
All right, thank you very much, everyone, and bye-bye.
Hussein, the way you say bye-bye, like... all right. Bye, guys. Have a wonderful weekend.
Bye-bye.
Yeah.